Hi, I'm Paula Vincent Johnson, a Louisiana civil law notary. I help families secure their legacies with powers of attorney, wills, small successions, and real estate transfers. Today I want to talk to you about specific steps you can take right now to protect and secure your legacy with powers of attorney and wills, successions, real estate transfers, payable on death accounts, life insurance, and retirement accounts. So stick around for the entire video so that you get the full picture of what you can do today to prepare your family for emergencies, illnesses, and death. Powers of attorney and wills are an important part of your overall estate plan. They should be used in conjunction with life insurance and retirement planning. Of course, you would talk to your agent or financial planner about those last two. Powers of attorney allow you to name someone you trust to manage your assets in the event that you are not able to handle things on your own. If you become mentally or physically incapacitated. The person you name can manage and safeguard your finances and your property. They'll be able to access the money needed to continue paying your utilities, the taxes and insurance, and whatever other maintenance is required to keep up your property so that you don't lose it, and ensuring that you have something to leave to your loved ones. Dying without a will can have unintended consequences. So, in order to protect your legacy, you'll want to get your will prepared so that you determine who inherits your assets, thereby keeping your property in the hands of those you really want to have it and who'll appreciate the inheritance. Sometimes when people inherit property from somebody they didn't have a close relationship with, they're not interested in maintaining and protecting that property. That's how families end up losing the legacy of land and other assets left behind. There was no plan for distributing those assets. So make your plan, get your will prepared. A succession is the legal process of transferring title of a deceased person's assets to his or her heirs. If you've inherited property, you want to get the succession done as quickly as possible. This not only protects your legacy, but also the legacy of the person who left you the property. When you don't do successions, you are passing that task on to the next generation and the next and the next. As heirs in each generation die, all of those successions have to be done before property can be mortgaged, sold, or donated. This again is how property is lost due to a lack of interest in handling the legal matters necessary to keep property in the family. The quicker successions are done, the better. At that time, too, the family can address the issue of whether an heir wants to remain involved with the property. I often work with families who want to quickly and easily remove an heir's name from property by donating it to those who are interested in keeping it. Real estate transfers can also be beneficial in helping you to secure your legacy. You may want to donate property to a loved one while you're still alive. For instance, parents may donate property to their adult child now instead of later as an inheritance. If that child is married, one of the ways that you can protect your legacy is by donating the property to that child as his or her separate property, so that ownership stays with your child, not with their spouse. Now, there are tax and other consequences related to donations, so you should check with an accountant, a tax preparer, or an attorney to confirm the benefits or disadvantages in your particular case. However, if you're certain that you're ready to move forward now with any donation, not just to your child, I can help you get it done quickly and easily. Most banks and credit unions will allow you to name beneficiaries on your accounts. These are called payable on death or POD accounts. With this type of account, you will sign an affidavit, which is a notarized statement, naming a beneficiary to receive whatever funds are in that account at the time of your death. Usually, the beneficiary will only have to produce a death certificate and valid identification in order to receive the funds in an account designated for them. Also, most financial institutions will simply make your existing account a POD account. There's no need to open new accounts. Check with your bank or credit union to confirm their procedures and requirements before you convert any of your accounts. Life insurance and retirement accounts are a great way to protect your legacy, but only if your named beneficiaries are up to date. Check your policies, especially if you haven't looked at them in a number of years. This is really important. I can't stress it enough. Insurance companies and financial institutions are required to pay out proceeds to whomever is listed as the beneficiary. I've talked to people who have totally forgotten about particular life insurance policies and retirement accounts. I once talked to a gentleman whose life insurance policy at work still had his ex-wife listed as the beneficiary. Believe me, that was not his intention, as he had gotten remarried. He just had not thought about that policy for years. So check your beneficiaries on all of your policies to confirm they properly reflect your current wishes. Also, whenever you can, you should list a contingent beneficiary. That's another person who will receive the insurance benefits if your primary beneficiary dies before you. This is also a crucial element in insurance planning, because if your primary beneficiary dies before you and you don't remove their name from your policy, or you haven't listed a contingent beneficiary, you could cause your family and theirs a lot of problems. Here's an example. If you list your sister as a beneficiary and then your sister dies first, but you never remove her name from the policy and there is no contingent beneficiary, the insurance company may be required to pay out the proceeds to your estate or your deceased sister's estate, depending on how the policy was first issued. It's very likely the insurance company will require your heirs or your sister's heirs to do a succession before they release any money. And that could be a lengthy and expensive process if the family has to hire an attorney. Alternatively, I may be able to help with an affidavit of small succession, depending on the value of the deceased person's estate. Please confirm your beneficiaries. The insurance company will guide you on what you need to do if you wish to update that information. If you wish, now might be a good time to make a list of all your financial information and make sure that someone you trust knows where to find it. Be careful, though, about leaving written passwords and account information unprotected so that it doesn't end up in the wrong hands. Okay, I hope this year is starting off as a good one for you. If you have questions about powers of attorney, wills, small successions, or real estate transfers, go ahead and schedule a telephone consultation with me so that you can get the clarity you need to move forward. I'll listen to your concerns and goals and answer all of your questions. There's a link to my online calendar in the description. Remember, getting your legal documents in order protects and secures your legacy, making sure that your family is prepared for emergencies, illnesses, and death. If you like the information that you just received, please like this video, subscribe to this channel, and click the bell so that you know when new information is available. You can visit my website and follow me on Facebook and Twitter, where I give quick answers to your quick questions. When you connect with me, I promise you'll learn something. I appreciate you so much. Thank you for watching. I'm Paula Vincent Johnson. Come back to see me next week.